So I have an important update for you all in the Duncan v. Bonta California magazine ban case. So let's talk about what is happening. But real quick before we jump into this video, if you think a ban on magazines is clearly unconstitutional, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is Sonoran Desert Institute. SDI is an accredited online college that helps students learn the skills and techniques they'll need to be successful in the firearms industry. So if you enjoy gun repair, ballistics, and learning about firearms, SDI might be a good option for you. To find out more about SDI, you can visit them using the website linked down below. And thank you again to SDI for sponsoring this video. So as I mentioned in the intro, I have some updates for you in the California magazine ban case Duncan v. Bonta. You may recall that recently a 9th Circuit en banc panel decided to fudge some of their rules and take review of this case immediately. This was an unprecedented move by the 9th Circuit and really shows how the 9th Circuit, especially this 11-judge panel, is still dedicated very much to violating Second Amendment rights and pretty much just outright defying what the Supreme Court recently said in Bruin. The 9th Circuit issued a recent order indicating that they are going to take this case as a comeback case, and then they decided to issue a stay against what Judge Benitez said once again, which was his second favorable decision that he issued striking down California's magazine ban. That, of course, was not really unexpected because the 9th Circuit broke their own rules with the express purpose of kind of taking control of this case once again and then issuing a stay on that favorable decision. And now multiple states have also jumped into this lawsuit and in fact are supporting California and their magazine ban, which is not good. The arguments have also started in the 9th Circuit en banc panel on why this magazine ban should in fact be found unconstitutional. Now, for those not aware, Duncan v. Bonta involves the California possession and purchase ban on certain magazines that hold more than 10 rounds. This law was challenged and a district court judge, Judge Roger T. Benitez, issued a ruling and found that this law in California in fact does violate the Second Amendment. This led to what is called Freedom Week in the state of California. Many of you are probably familiar with that, and you're probably still in possession of Freedom Week magazines because of that first decision. Now, after that first favorable ruling, the state of California, of course, decided to appeal up to the 9th Circuit. And on original review, a 3-judge panel in the 9th Circuit reviewed the case and ruled in favor of Judge Benitez and us in the state of California, finding that Judge Benitez's decision was in fact correct. Well, again, the state of California was not going to let that decision sit, so they filed an en banc review petition to the 9th Circuit. The 9th Circuit took this case en banc. A randomly selected 11-judge panel, which makes up the 9th Circuit en banc panel. It rotates, it's random, it's not like other jurisdictions, but this original 11 randomly selected judges reviewed the case and then ultimately ruled in favor of the state of California. That decision by the en banc panel, which used the incorrect type of analysis, it used interest balancing and intermediate scrutiny to rule in favor of the state of California. Well, that then was sent to the Supreme Court, the U.S. Supreme Court, for review. There was a petition for the Supreme Court to look at what the 9th Circuit en banc panel said, and ultimately what ended up happening is the U.S. Supreme Court issued their landmark decision in New York State Rifle and Pistol Association versus Bruin. Now, after they issued that Bruin decision, the Supreme Court granted, vacated, and remanded the Duncan case back down to the 9th Circuit for them to re-review the case and rule in light of that recent Bruin decision. Now, at that time, the 9th Circuit could have reevaluated the case, but they decided to instead send the case back down to Judge Benitez because at that time, the 9th Circuit and this en banc panel wanted absolutely nothing to do with 2A cases. So the case was back in the hands of Judge Benitez, and then on the Attorney General Rob Bonta's birthday, Judge Benitez released his decision in Duncan. And ultimately, he ruled once again that California's magazine ban, in fact, did violate the Second Amendment, and therefore he issued an order to prevent it from being enforced once again. Now, in that same order, he also did give a 10-day stay on his decision for the state of California to appeal and then also seek a stay from the 9th Circuit, which they promptly did do. California filed an appeal and then also a request for an emergency stay on that Judge Benitez decision. Now, that went to the 9th Circuit and it was supposed to go to a 3-judge panel. Then something unprecedented happened in this case. We received an order from the 9th Circuit en banc panel, the same 11 judges who reviewed this case prior, that they were going to take review of this case and also review of that emergency stay request instead of letting it go to the traditional motions panel and a traditional 3-judge panel. This 9th Circuit en banc panel claimed that under their rules, they could take this case as a comeback case and rehear it on their own. Then the 9th Circuit en banc panel issued a stay on that Judge Benitez decision. They granted the emergency stay in the state of California's favor, and then now they are taking review of this case and will redecide this case potentially. But even in that order, taking the case as a comeback and in the granting of that emergency stay, we received some important dissents and information from judges like Judge Van Dyke and Bumate, essentially calling out this Ninth Circuit 11-judge panel for pretty much just breaking their own rules expressly with the intent of protecting California's magazine ban. So there was a lot of potential bias and corruption that was revealed by some of the judges on the actual Ninth Circuit en banc panel. But despite all of that, this case is still proceeding forward in the Ninth Circuit en banc panel and will be reviewed by the same 11 judges who were selected originally in the Duncan case. Now, briefing has started in this case, but recently multiple states and attorney generals have jumped in and have also filed for amicus briefs in support of California and their unconstitutional magazine ban. Those states who have joined in support of California are Massachusetts, New Jersey, Arizona, Colorado, Connecticut, Delaware, the District of Columbia, Hawaii, Illinois, Maine, Maryland, Michigan, Minnesota, New York, Oregon, Pennsylvania, Rhode Island, Vermont, Washington, and Wisconsin. All of those states support the California magazine ban and want this Ninth Circuit en banc panel to uphold this ban, even in light of what the Supreme Court recently said in Bruin. Now, in their brief, the states argue that although our regulations differ in substance, we share the firm conviction that our Constitution allows the states to address gun violence in a manner adapted to local needs and consistent with our nation's historical traditions. In accordance with these objectives, the amici states urge this court to conclude that California's limitation on the size of ammunition magazines comports with the Constitution. So a bunch of states are joining together to argue that the California magazine ban is constitutional and that they also could potentially put in place magazine bans if they want. And some of these states are also potentially trying to protect their own magazine bans. Now, the plaintiffs have also filed their brief to the en banc panel. Michelle and Associates, the attorneys for the plaintiffs, are essentially arguing first that if this en banc panel decides to proceed forward with this case and rule on this case, they should uphold what Judge Benitez said down below, that he said it twice before, especially in light of what the Supreme Court recently told them in Bruin. Now, here they state that when California Penal Code Section 32310 was last before this en banc panel, the court upheld the state's ban on common arms under intermediate scrutiny and declared that if the Supreme Court wanted a different outcome, it would have to tell us itself that this circuit and others had fundamentally misunderstood the basic framework for assessing Second Amendment challenges. The Supreme Court responded to that clarion call, emphatically rejecting the two-step intermediate scrutiny test as fundamentally flawed and making clear once and for all that the Second Amendment protects the possession and use of weapons that are in common use. Then, for good measure, it vacated and remanded this panel's decision for further consideration in light of Bruin. The fate of California's ban on common arms should now be clear, and to the district court, it was. But to hear the state tell it, the Supreme Court's paradigm-shifting decision in Bruin makes no difference at all, except perhaps to somehow expand states' latitude to restrict law-abiding citizens' ability to keep and bear arms. That sounds absurd because it is. A straightforward application of Bruin confirms that California's ban is unconstitutional. They then point out and argue that this current 11-judge en banc panel should not be reviewing this case at all. And again, this is supported by what Judge Van Dyke said, and even the Ninth Circuit en banc panel here also indicating and requesting additional briefing on this issue. The plaintiffs argue that either the Ninth Circuit should send this case back down to a 3-judge panel for consideration, or they should redraw the required randomly selected 10 judges plus the chief judge and re-review this case en banc. But this same 11-judge panel taking this as a comeback, breaking their rules, should not be appropriate and should not happen. So the strategy seems to be first to point out to this panel that the Supreme Court has already expressly rejected their analysis, and they rejected the analysis they performed before in this case, and the Supreme Court even granted, vacated, and remanded the case back down to them because they got it wrong before. If they redecide this case, if they continue with this case and rule on the merits, then they must faithfully apply Bruin and no longer just completely fudge whatever test that they want, do whatever they want. They need to adhere to what the Supreme Court said in Bruin and not continue to defy it. Second, the plaintiffs argue that this current en banc 11-judge panel does not have the statutory or procedural authority to review this case. They have violated the clear rules and that they should either redraw the panel or send this case back down to a 3-judge panel for review. It seems like they've already been willing to get their hands dirty, so I don't suspect that they're going to do us any favors. I think they're going to probably continue with review of this case, say that they can review this case. I suspect that they're going to completely butcher the Bruin analysis and just uphold the magazine ban, probably saying that these arms are not protected, that magazines are just accessories, or they're going to just completely come up with whatever test they want and just not apply Bruin. So for everybody asking me what's going on with the magazine ban case, that's what's happening. If you have any questions, go ahead and comment down below and I will try to answer the best of my ability. Also, if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, but never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.